Yes, be ready, start. If action is taken under section 17 within bracket 1, taking possession and vesting which are provided in section 16 after the award under section 11 are accelerated and can take place 15 days after the publication of the notice under section 9 stop. Then comes section 17 within bracket 4 which provides that in case of any land to which the provisions of subsection within bracket 1 are applicable, the government may direct that the provisions of section 5A shall not apply, and if it is does so direct, a declaration may be made under section 6 in respect of the land at any time after the publication of the notification under section 4 within bracket 1 stop. It will be seen that it is not necessary even where the government makes a direction under section 17 within bracket 1 that it should also make a direction under section 17 within bracket 4 stop. If the government makes a direction only under section 17 within bracket 1, the procedure under section 5A would still have to be followed before a notification under section 6 is issued, though after the procedure has been followed and a notification under section 6 is issued, the collector gets the power to take possession of the land after the notice under section 9 without waiting for the award, and on such taking possession the land shall vest absolutely in government free from all encumbrances stop. It is only when the government also makes a declaration under section 17 within bracket 4 that it becomes unnecessary to take action under section 5A and make a report thereunder stop. It may be that generally where an order is made under section 17 within bracket 1, an order under section 17 within bracket 4 is also passed, but in law it is not necessary that this should be so stop. It was emphasized that there must be an application of mind by the appropriate government to the facts of the case with special reference to the necessity of dispensing with the unvaluable opportunity of showing cause and being heard against the accusation consequent upon a section 4 notification stop. It should be noted that prior to the amendment of the statute in 1923, since the right to file objection to the proposed expropriation of land was non-existent, there was no reason whatsoever to refer to the dismissal or disposal of section 5A objections stop. It is advisable, if not essential, to keep the annals of the statute in mind while interpreting its sundry sections stop. The learned CIT further explained that the assessing authority has examined the relevant details of the transactions in an exhaustive manner and has made out a very clear case that the intention of the assessee was not to buy any machinery and lease back the same for the purpose of earning any lease rent stop. The only object of the assessee was to claim 100% depreciation stop. It is a clear instance of colorable device employed by the assessee to reduce its legitimate tax liability stop. The CIT within bracket A also has examined various aspects of the lease agreements and has come to a concrete finding in agreement with the assessing authority stop. The learned CIT further explained that the special bench has laid down a series of tests to be applied before adjudicating similar issues stop. The tests laid down by the special bench are such as whether the parties had any intention to pass the properties in the equipment, whether the equipment identified the ascertained with reasonable clarity, whether the equipment was properly valued, what are the terms of the lease agreement, or whether they were only agreement for the security of the loan, etc., etc. stop. The facts of the present case do not answer any of the tests laid down by the special bench has stated above stop. She therefore submitted that this is a clear case of financing transactions and not lease transactions stop.